Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1592. Judith Peterson and Daniel Gerhard Brown, appellants versus United States Department of State et al. Mr. Hempy for the appellants, Ms. Fosterberg for the appellees.
Good morning, Your Honors.
Good morning, Mr. Hampy.
Carl Hampy with the Fragaman Law Firm for appellants Judith Pietersen and Dan Brown. May it please the court, Your Honors. This court can hear Ms. Peterson's challenge to the erroneous instruction in the Foreign Affairs Manual, the FAM. There's no authority to support the government's overly broad claim that it can draft an unlawful guidance insulated from judicial review simply because it'll end up in the hands of a consular officer and contrary authority supporting review from this circuit. The State Department's FAM instruction on the willful misrepresentation ground is clearly unlawful, as the district court incorrectly applied an interim ground of consular review and its reasonably standard to the ultimate determination of admissibility, which requires willfulness. And finally, appellants ask that this court direct the State Department to correct its mistaken FAM instruction so that Ms. Peterson can have a fair shot at a future visa application.
Where in your complaint do you challenge this FAM policy? Because I read your complaint to just challenge the actual visa denial for Ms. Peterson.
The complaint in a number of instances states that specifically in paragraphs 13, 15, 57, and to Your Honor.
Okay, well, can we slow down? You said 15?
Yes.
So,
I'm sorry, not 13. Second, I have it here. If I may, Your Honor, let me just.
So the reason I'm confused is because your prayer for relief says that you request the court hold that defendant's inaccurate description of the willful misrepresentation ground of admissibility to be in bad faith, not bona fide or facially legitimate, and that it vacate Ms. Peterson's recent visa refusals and direct the State Department to refrain from applying an improper standard of evidence.
Yes, Your Honor. In the third paragraph in the prayer for relief, we ask that the court find and declare the defendant's inaccurate description of the willful misrepresentation ground of inadmissibility in its Foreign Affairs Manual to be in bad faith and unlawful. And that was the relief.
But there's no sort of APA or like cause of action or anything. It just seems that this complaint is really geared towards this specific visa application.
When this complaint was filed, there's some procedural history that's important here, Your Honor. When this complaint was filed, the Munoz case hadn't even been accepted for cert by the Supreme Court, so a due process claim was still viable. As the subsequent oral argument in the district court showed, it no longer is. In the district court, we clarified that we still had a mandamus claim to direct the Secretary of State to perform the duty he owed to Ms. Peterson and to Mr. Brown to
but that's properly geared towards the actual application as opposed to the general policy, isn't it?
It was, we made it very clear in post-oral argument briefs before the district court that the mandamus claim also applied to, was our basis for challenging the Secretary's failure to properly implement the statute by drafting an unlawful FAM guidance.
But your appeal is not of the mandamus issue.
Our appeal is of the FAM's, Our appeal does not challenge the consular officer's decision. Our appeal asks this court to exercise its authority that it did in the bricklayer's decision by looking at the FAM instruction.
I understand. I guess what I'm trying to understand is where you preserve that argument for appeal, because your complaint does not appear to challenge the FAM in that respect. And you just told me about the mandamus litigation, but you're not challenging the mandamus decision. So I'm trying to understand how it is that this is properly before us as a challenge to the FAM as a policy.
Your Honor, the immigration laws, Section 1104A, charge the Secretary of State with properly administering the immigration laws. That creates the duty that the Mandamus Act we submit it may be used by this court to encourage or to direct the executive to properly implement the immigration laws through based on its responsibility in 1104A.
I see, but you're again going back to the mandamus. Is that what's before us right now? You're asking us to issue a writ of mandamus?
Yes, Your Honor. Here was Your Honor, our conundrum was the following, which was when, after the Munoz decision was made and after the district court ruled, we normally would have just gone back to district court and amended to clarify everything, to have more clearly pled the APA, not merely as a jurisdictional basis, but also as a basis for relief, and shown how the mandamus claim would also apply. Unfortunately, the district court decision clearly set forth how futile that would have been by saying, look, the doctrine precludes me from even considering this case, and here's the way I read Section 1201G of the immigration laws to eliminate your argument, to sustain the FAM's reason to believe statute, reason to believe standard. We normally would have gone back. If it hadn't been futile to go back and amend, we would have. But the district court made clear that we couldn't. And so the relief we're asking for here in the alternative, if this court isn't comfortable with just directly striking the FAM instruction that we submit as unlawful and that we submit, this court through mandamus has the power to direct the secretary to strike the offending language, would be to allow us to. Is there a mandamus
argument in your briefs?
Yes, Your Honor. And it was fully put before the district court. The district court didn't decide it. These were in the post-oral argument briefing. We said, that's on page 2 and page 6 of our post-oral argument briefs before the district court. We said we believe the FAM, that court had authority under.
I'm talking about your brief before us.
Okay, yeah. Yes, I believe it's in our reply brief, Your Honor.
Well, you can't raise a new argument in your reply brief, can you?
We submit, Your Honor, it was not a new argument because mandamus was a part of our claim below. Mandamus was a part of our argument in the post-oral argument hearings before the district court.
I think on page 19, mandamus of the blue brief mentions mandamus. In the beginning of that first paragraph starting on page 19, the court has permitted mandamus actions challenging delays.
Yes, thank you, Your Honor. Page 19. Second, courts have clarified that future decision-making by a consulate does not trigger the doctrine, and this court has permitted mandamus actions challenging delays in the process of issuing a consular decision on the grounds that consular non-reviewability does not attach until after a final decision has been made.
I'm a little confused. Maybe it's the same issue, maybe it's just a related issue. It struck me that this is really an APA challenge to the Foreign Affairs Manual. I'm not sure why. I mean, mandamus would be if you were challenging the specific visa denial, but if you're looking for declaration or, relief that the Foreign Affairs Manual in this respect is contrary to the statute, would that be a satisfactory approach?
Yes, Your Honor. Certainly, if we had been able to go back, if the district court decision hadn't clearly cut us off from going back to amend, in light of the Munoz decision, we would have gone back, amended, and filed an APA cause of action with the district court. But the district court said, don't bother because the doctrine cuts you off, and don't bother because 1201G has the reason to believe standard, which we submit as clearly erroneous.
So I think you didn't get a chance to finish your sentence. You said we should either invalidate the district court's reading of constitutional non-reviewability, or alternatively, and I thought you were going to say remand.
Yes. In the alternative, this court could strike the district court holding that the 1201G reason to believe standard applies to the actual inadmissibility determination and clarify that the doctrine doesn't preclude review of the FAM itself, and then remand with an opportunity for us to amend to, as you point out.
So on the merits of the challenge that the Foreign Affairs Manual conflicts with the statute, I'm not sure I follow the argument, because the statutory provision doesn't say anything about the quantum of evidence of misrepresentation that a consular officer needs to deem an applicant inadmissible under subsection 1182 A6C1. It just doesn't, there's nothing in that contradicts the manual's use of reason to believe. And then, as the government argues, under section 1201G, which categorically says that consular officers should not recognize an applicant as eligible if the officer knows or has reason to believe that they're not eligible. And
Sure, Your Honor, yes.
I understand the expressio unius, that some of the other subsections explicitly use reason to believe, but you never point to anything in the act that provides an alternative standard, a higher standard. So it's really unclear from your briefing what standard you even think does apply and where you find it in the statute.
The standard is willfulness, Your Honor, meaning elsewhere in 1182A, where the other grounds of inadmissibility are set forth, when Congress wanted a reason to believe standard to apply, it said so for potential money laundering, for drug trafficking, for material support of terrorism.
Right.
Otherwise, it is the words of the statute, and it said you are inadmissible if by fraud or willful misrepresentation you assert a fact or you omit a fact that's material to your visa application.
But doesn't that mix, that's sort of apples and oranges. The question is reason to believe there's willfulness, or a finding by the preponderance of the evidence that there's willfulness. Like, I thought you were gesturing toward a different quantum of evidence. You're right that the merit standard that the consular officer should be thinking about is fraud or willful misrepresentation. But I thought you were challenging the standard of allegation or proof or
yes, Your Honor, we're challenging two things. We're challenging the quantum because reason to believe is certainly below preponderance, which is the default standard in the immigration laws. But we also challenge the second part of the FAM instruction, which says, if an individual engages in conduct inconsistent with their non-immigrant status within 90 days of visa application or admission to the U.S., you may presume that the applicant made a willful misrepresentation, i.e. you may presume that the applicant's representations about engaging in only status compliant activity were willful misrepresentations. And it is those two parts of the FAM instruction taken together, the reason to believe, and then the presumption of willfulness, simply by a fact pattern. Those two taken
Presumption
together.
of willfulness is where? I'm sorry, you gave a citation, but I missed it.
It's in that same FAM instruction on the willful misrepresentation ground of inadmissibility. It's a little further down, 9 FAM 302.9. We can see. It's, let me see. We have, I think I have it here. I have the whole thing here. But we clearly in our papers challenged and in our briefing challenged both the reason to believe and the presumption, and the presumption just doesn't work with a willfulness standard. And particularly as we've pled it, Your Honor, we showed how Ms. Peterson fit precisely into the fact pattern for the presumption. So we submit, Your Honors, that this was the cause, and we certainly satisfied the causation requirements.
Which, can you just, I think it's JA 171 onward, the language that you're referring to about you may presume that you're challenging.
Is this argument in your briefs?
Yes, Your
The
Honor.
challenge that you will presume?
It
Where is that?
is. My apologies. Your Honors, we begin our discussion of this on page 12 of our opening brief, where we here on page 12. We discussed the FAM provision here, 9 FAM 302.9-4B3G1
I know, but you're specifically arguing now that there's a provision about you will presume and that that's not appropriate.
And
I
yes.
don't remember seeing any argument about that.
So I think I submit we did, Your Honor, but let me find that provision.
I mean, what I'm seeing is, oh, here we go at the bottom.
Yes.
206, page JA 206. Basically, the last paragraph on page 206, if an individual engages in conduct inconsistent with their non-immigrant status within 90 days of visa application or admission,
It's just
you may
not in,
presume the
You
application
may presume.
made a willful misrepresentation.
no, I understand. I don't think it's in the brief.
Yeah.
I don't think you
Yeah.
can argue that.
I believe it is, but I'm sorry, I'm fumbling with papers and didn't have the precise point.
Yeah,
for
I
you.
don't think it refers to this particular presumption, but the point is we understand the argument you're making now. So you were in the process of responding to my question, how there's a conflict between the terms of the INA and the use in the manual of the reason to believe standard. And you said that the default standard in the INA is preponderance. I don't see you citing anything for that. And I may not have read carefully enough, or I may be forgetting. But I didn't see that standard.
Your Honor, that I can say for certain. We didn't include that argument in our briefs because our view of this was that the reason to believe standard and the presumption combined to clearly make inoperative the willfulness standard.
Well, presumption could be rebuttable. What is the evidence that Ms. Peterson was not willful in violation of the visa terms?
Yes, Your Honor. And if I may just give a brief summary of what happened here. Ms. Peterson came in 5 years ago, presented herself for entry at the Minnesota airport under the visa waiver program as a visitor, visa waiver as a visitor. CBP turned her around, did not find her inadmissible, but said, we're not convinced because you've been here a lot that you're eligible for the visa waiver visitor status. Go back and get a visa. So Ms. Peterson went back to the consulate in Amsterdam. She applied for a visitor's visa. It was refused. She and her appellant Dan Brown had been engaged, so she filed a fiancé visa. And at that point, the consular officer in Amsterdam first lodged an inadmissibility determination for misrepresentation. 1201G is an interim basis for a consular officer to make a decision. And that officer could have used that statute to say, you may fit a fact pattern here. I should cast the net broadly using the reason to believe standard and determine whether or not a ground of inadmissibility applies, because that bar would be for life. The consular officer did not do that, but that's the function of 1201G. And that's why Congress had the reason to believe standard to catch the wide net, cast the wide net. It's an interim basis for a decision, as the district court said.
What kind of net they cast?
I'm sorry?
How do you know what kind of net they cast? Are you
Well, they cast.
assuming they didn't research this?
The consular officer in that instance cast no net whatsoever. I was just explaining what.
How do you know that?
It was alleged in our complaint. She went. It was a quick interview. A 1201G determination is usually followed up by, you are hereby in administrative processing. The State Department has a form. They check the administrative processing box, and under 1201G.
I'm just trying to get at, I'm just trying to understand your argument, because I guess you're saying that they didn't do enough work to understand why she's not eligible. But I thought there was a Facebook post that she was in a dressage, she worked.
Yes.
Got money.
And that's what.
So they had that information.
That is what the CBP officer used to say, what's going on here? She said, well, yes, I did. I did do this.
Cast a wide net argument, because it seems like they had a factual basis. And how do you know they didn't cast a wide net?
Because she was never given an administrative processing determination. I was saying that Congress, in creating the reason to believe standard in 1201G, allows a consular officer, in theory, casting a wider net to put somebody in administrative processing to determine whether or not a ground of inadmissibility applies. But when the determination is made, it's not made under a reason to believe standard. And we submit that the statute doesn't allow presumptions to apply. So the consular officer has to say, well, you willfully misrepresented to that CBP officer that you were coming purely for visitors' purposes, when she said, she never denied that she came for, in part, dressage lessons. She said, yeah, I didn't know that was unlawful. She made no misrepresentation whatsoever.
So you're helpfully describing two different types of determination, a kind of provisional interim determination that is based on reason to believe.
Correct.
And that triggers, as you say, a process where she could have an opportunity to make her case.
It could,
And
right,
that
which didn't happen here.
Right, and that would involve more opportunity to sort of clarify and get a determination. And so what you're saying is that they collapsed that interim decision and made it sort of final and lifelong? Did you say permanent?
Yes, so there is no requirement that the consular officer issue an interim determination. But that explains why 1201G has a reason to believe standard. In this instance, the consular officer in Amsterdam looked at whatever the officer looked at and said, look, you're inadmissible. So went to the final determination. A 212A6C, 1182A6C determination is permanent, right? It is, unless Ms. Peterson can go back, and this is our request, that she be able to go back and apply for a new visa and convince a consular officer that she's not inadmissible, she is inadmissible permanently. Waivers are available, but they're under stricter standards of hardship, and they're completely discretionary.
I guess if you're saying that so you're saying the Foreign Affairs Manual categorically misapprehends this scheme that you're describing, where there's an interim determination and then a full-on permanent determination? Or that the CBP official misapplied it by treating what should be an interim determination as a final?
There was only one mistake. The only one agency made a mistake here, Your Honor. CBP made no mistakes. It never found Ms. Peterson inadmissible. It simply said, we're not sure you qualify to enter as a visitor. Go back and get a visa. She did go back. When she applied for the visa, for the fiancé visa, the consular officer applied a ground of inadmissibility that required a willful, by statute, that she have willfully misrepresented to the CBP officer then, or during other admissions, that she was coming for a purpose other than her primary purpose, and that she had done so willfully, knowingly, with intent to deceive, right? She did nothing of the sort. She said, I thought I always could. And the Foreign Affairs Manual, which is what we seek the remedy for, which is what we seek to challenge.
Where's the willfulness standard? Oh, any alien who willfully
by fraud or
okay,
or willfully misrepresents a material fact is inadmissible. 1182A6C.
I see.
And fraud, of course, it's deceit. It requires intent, willful misrepresentation of a material fact. The statute there is pretty clear. It's a permanent and onerous ground of inadmissibility. It shouldn't be entered into simply by a FAM instruction that says, well, go ahead and presume this. Because if someone does something inconsistent with the terms of their visa category, you may presume that they made a willful misrepresentation. That's what the FAM instruction says. We submit that's clearly unlawful. We submit this court has jurisdiction, notwithstanding the doctrine of consular non-reviewability, to look at that FAM statute and instruct the State Department to correct it so that in the future, when Ms. Peterson applies again, because she will, because she's going to be married to a US citizen, she at least has a level playing field upon which to establish her eligibility.
How are you going to get review of that in light of consular non-reviewability?
I'm sorry, Your Honor?
How are you going to get review of that in light of consular non-reviewability the next time it happens?
Your Honor, we will take, if this court would strike the offending FAM instructions, we will take our chances. We submit this court can review the FAM instruction, notwithstanding the doctrine. We understand that we can't seek review of the prior refusals, And we can't seek review of a future refusal,
Future refusal.
of a future refusal if it's, of a future refusal.
Refusal, period.
Yes, period.
So I'm not sure what the point of all this is. You're going to lose no matter what.
Oh, Your Honor, we submit, we
right?
won't lose if the offending FAM instruction isn't there, because then there will be no presumption that when she
How will
entered.
you know that in light of the doctrine? If you're simply, your client is simply declined. It's not reviewable by us.
A future refusal would not be reviewable
Right.
if we get a future refusal. Your Honor, we submit that her injury here was the offending FAM instruction, which caused the prior refusals. And we submit the Secretary of State has a duty to administer the immigration laws consistently with the statute, including by having FAM instructions consistent with the laws. We'll take our chances going forward, but that would be meaningful relief. We submit, and that's how we've pled it.
Thank you.
Good morning, Your Honors. May it please the Court, Kara Alsterberg on behalf of the United States. Ms. Peterson has been found inadmissible by 2 different consular officials, and she cannot enter the United States.
Can you just sketch for us the distinction between eligibility and inadmissibility?
Here, she's been found inadmissible underneath 1182 A6 C1, which is that, and as discussed with the counsel across the aisle, was that she willfully made a material misrepresentation. And that was when she was on a tourist visa, she entered the country claiming to be within the country for tourist reasons, when in fact she subsequently received payment for work. This was found in the Facebook group relating to the dressage, and even Ms. Pietersen herself admitted in a declaration as part of the amended complaint that states that she did receive nominal compensation for work performed.
Okay, she admitted that she did it, but willfulness requires at the time of entry on the visa that you have an intent to do something that's prohibited by the visa, and there's no showing of that I understand.
We're already looking behind the veil of consular non-reviewability.
Well, right, but I'm trying to understand how the process works. I fully appreciate the consular non-reviewability, but in terms of the going forward issue, I'm just trying to understand the government's view of the basis of the non-reviewable determination of willfulness.
So here, all that is required is that a consular official found her inadmissible pursuant to 1182 A6 C1.
And that is
that's enough.
Permanent bar.
That is a bar that can be waived through an I-601 waiver, which is a form that allows non-citizens to immigrate to the U.S. when they're otherwise inadmissible. They must demonstrate their inadmissibility would cause difficulties for their family members.
And I asked you what the difference is between eligibility and inadmissibility, and I gather eligibility is more episodic, visa specific, and ineligibility is a kind of categorical.
Yes. So here, under a typical consular non-reviewability, a typical case where a consular official looks at someone, a non-citizen trying to enter the United States on a visa, what's required is they have that interview, and then afterward, pursuant to 1182B, all that's required is a written denial or the determination, and then a citation regarding what the reason for that denial was. And here, that was met. That's all that's needed. And technically, even if there was some type of exception, some type of constitutional exception, that meets the standard even under a facially legitimate and bona fide standard for what is required. And here we have even more information than that. We know what the problem is. The problem is that she came here on an ESTA and received payment.
So even if we can't reach this because of consular non-reviewability, it seems like the facts are she earned some money doing this dressage thing, which violated the terms of the visa. But what's the reason to believe that it was willful?
All that's required is that the consular officer, we don't know necessarily what they looked at to make that determination. That's also an assumption that's being brought in by appellants, is that there was an assumption that there's a reliance on this FAM guidance or, upon information and belief.
No, I understand we might not get to this because of consular non-reviewability, but if all the facts is that she did something and then she's not admitted because there's reason to believe that it was willful, I don't see how there's reason to believe that it was willful if all you know is that she did it. You don't know what she was thinking when she did it.
Well, to provide maybe a little more context, the FAM does actually have standards for what a finding of fraud looks like and what a finding of willful misrepresentation looks like. That's 9 FAM 302.9-4 capital B2.
And what JA page to help us out?
That might be in our...
Right, in your addendum?
Yeah. Oh, the FAM's not in that one. That might be actually in the to add FAM sites at the end.
Are you on 203, the INA misrepresentation?
Or 207, inconsistent conduct?
203, 204?
The interpretation.
Of the term misrepresentation?
Yes.
Page 204 of the joint appendix?
Apologies, I just want to make sure.
It says, for example, 204, I'm looking at 302.9-4B3, subdivision B, necessary to distinguish between misrepresentation of information that was merely concealed. Silence or the failure to volunteer information does not in itself constitute a misrepresentation. So it's unclear what she said that was a misrepresentation. I guess the form of the government's argument is the form of the visa was a purely tourist visa, and that's a representation. I'm only going to be there as a tourist.
Yes.
And is it not material to the government that the person doesn't realize that the nominal compensation that she got was inconsistent with tourism?
Yes.
Just presume. Circling back to so is it the government's position that this kind of misrepresentation determination is under the INA made under a reason to believe standard?
I think the district court laid out the fact that 1201G is the operating statute related to 1182, and that it was not completely out of left field that a reason to believe standard would find its way into the FAM if...
I can't hear you.
Apologies, that 1201G is the operating statutory guideline related to the determinations that a consular officer will make. And that's what the district court also cited to explain how when a consular knows or has reason to believe that an alien is ineligible to receive a visa, under section 1182.
It seems a little bit bootstrapping because this says you don't issue if you think the person's ineligible, if you have reason to believe that they're ineligible. But what we're talking about here is a determination of ineligibility in the first place. And I'm wondering what the process is, according to the government, for making a determination. This person has engaged effectively in visa fraud or visa misrepresentation. They've come under false pretext. We're going to keep them out of the United States presumptively permanently, unless they get a waiver. And my question is, in making that determination, is it correct that the government does that, the consular officer, let's say, makes that permanent ineligibility determination based on a so-called reason to believe level of information, allegations?
That's in the FAM itself. Perhaps we can presume that that's something that the consular officer looks at.
Are you saying it's in the FAM at 1201G?
Or it's in the FAM as to how to conclude there was a misrepresentation. So that's the 3029-4B3 G1B.
4B3 G1. Find that.
What do you mean here? Reason to believe? Reason to believe what? That she engaged in fraud, or that she entered the country alleging she was coming in as tourist, but she also did some work, which is not necessarily fraud.
And that's why it's both fraud or a willful misrepresentation.
Well, I'm trying to give you the alternative of fraud and willful misrepresentation. She came in primarily on tourism, and she didn't assume anything untoward about doing a little money-making venture here or there. She didn't assume. So there's no way that anyone would, in a real case, say that that was evidence of fraud.
And it's here, it's under the misrepresentation standard. While that it subsumes both fraud and willful misrepresentation, it's someone who's sought to procure or has procured admission to the United States, such as entering on a tourist visa and then getting compensation for that. So the consular officer looks at a whole host of things, including the FAM, including the statutory text.
Does that have to reach a level of fraud?
That does not.
It doesn't?
It does have to reach a level of willful misrepresentation.
Yes.
Yes, and indeed, on JA 206, the provision you were looking at, G1, if you look at B in boldface, the fact that individuals' subsequent actions are inconsistent with what was represented at the time of visa application, admission to the United States, or in a filing for another type of amendment does not automatically mean that their intentions were misrepresented at the time of either the visa application or application for admission to the United States. And my question, which I don't think you've answered, but I think is really central to the government's position, is what is the level of the quantum of information that the consular officer needs to make a determination that someone is inadmissible based on a willful misrepresentation? Is it preponderance of the evidence? Is it reason to believe? Or is it some other standard?
It's unclear from the record what that standard would be or what exactly a consular
What is the position
officer
of the
looks
government
at.
as a matter of law?
Right.
That's a contested issue in this appeal.
Likely that the FAM guidance is not inherently incorrect and that it did appropriately apply.
It doesn't give a standard of proof. And so I wonder what you think the standard is. At least I don't see it. You know it way better than I do. So you should point us to where it says reason to believe or preponderance of the evidence or okay. Make a finding sufficient to meet the reason to believe standard. This is in the FAM. Now, what about in the statute? What's the best place to look? You see where I'm looking? Right after the bolded, it says, to conclude there was a misrepresentation. And this is the part that I take it that Ms. Peterson is challenging. That here, the FAM says, there only has to be evidence sufficient to meet the reason to believe standard. And the question is that consistent with the statute? And then you pointed me, I think, to 1201G.
Yes.
And that's what your brief pointed us to, that if it appears to the consular officer that an alien is ineligible, or the consular officer knows or has reason to believe that the alien is ineligible. And I guess the question is, this seems to refer to a determination, maybe just facts, showing ineligibility. So,
But this, from the government's perspective, is also not a unique case about the standard of proof that was applied. This is just simply appellant's way to pierce through consular non-reviewability because they disagree with the outcome of that decision. They
well,
disagree with the
let's
denial.
say a party comes with an intention to come to the United States and brings an APA challenge to the Foreign Affairs Manual, arguing that it's inconsistent with the statute. And let's say that person says, of course, when you're determining someone ineligible for life based on something that isn't, some of these drug trafficking or things that where there's a reason to believe standard for the ineligibility. And they say, well, look, some of these standards say that reason to believe is the ineligibility, sort of the burden of proof. And this one doesn't. And you say, well, no, it's reason to believe for all of them. And your cite for that is 1201G.
Or that it could capture that as well, that if we have to get to that question, which
Right.
in this case is not
I
broad.
understand you're not conceding that that is not this case. We're just trying to understand the nature of the claim and the nature of the government's position on it.
No.
All right. Did Mr. Hempy reserve time for rebuttal? We'll give you 2. I think we use more.
Yeah, Your Honor. I'll talk fast. Thank you. Your Honors, we mentioned the presumption language in the FAM on pages 4 and 11 of our opening brief when we said on assumption. The challenge FAM guidance allowed a finding of inadmissibility based on assumption. I concede we didn't quote the whole section, but we did refer to the FAM section that we were challenging in the brief. I would like to really underscore one point. The district court suggests that 1201G is the ultimate arbiter here because it is the source of the government's ability to find Ms. Peterson inadmissible. That is flat out wrong. The basis for Ms. Peterson's ineligibility is 1182A6C. 1201G is an interim determination by a consular officer. A number of cases in the district court, such as Shoei v. Blinken, Vulupala v. Barr,
Can you
9
slow down and
Iraqi
give us
allies.
citations? Did you cite those cases?
I'm not sure we did, but
We won't find them. If you didn't cite them, we won't find them if you don't give us,
yes.
speak more slowly and give us some.
Shoei, Shoaie v. Blinken. It's a Westlaw site. It's DDC November 6th, 2024, number 124 CV 0151. 13. There's also Vulupala, Vulupala v. Bar, 438 F sub 3rd 93, a 2020 district court decision. There's a well-known one, 9 Iraqi allies from 2009. All of these cases collect other cases showing that a 1201G determination is not final and interim in nature.
Did you make that argument?
Yes, yes, Your Honor. It all comes down to what does 1182A6C say? It says willfulness. The FAM instruction that we challenged so corrupted or so negatively affected the consular determinations that Ms. Peterson has experienced to date that she didn't get a fair hearing on whether she was inadmissible or not, because she didn't misrepresent her purpose when she entered. She acknowledged she had worked. She said, I didn't know that was unlawful. She's in the dressage industry, and there's a complex exception to what horse trainers can do on a B visa that influenced her answer. But putting that aside, there's no need to go that deep into the facts. Simply, she didn't misrepresent her purpose when she entered. CBP never said she misrepresented herself. When she went back, the consular officer in Amsterdam presumed that she had misrepresented because she fit the fact pattern that the unlawful FAM instruction placed before the consular officer. We submit that so thoroughly infected the adjudication and will do so in the future, that she and Mr. Brown are suffering ongoing harm going forward because she won't be able to get over this permanent inadmissibility if she isn't able to have a fair hearing absent the offending language in the FAM instruction. And we've argued why bricklayers and a number of other cases here allow this court to look at the FAM instruction. We would be very satisfied if this court would want to remand for us to state that more clearly in an amended complaint, which we felt we didn't have the opportunity to do, but was required now in light of the Supreme Court's ruling in Munoz.
Thank you.
Thank you, Your Honors.
Case number 24-7027. Darian McKinney, appellant versus District of Columbia. Ms. McAdoo Gordon for the appellant, Ms. Johnson for the appellee.
Good morning, Your Honors. Leslie McAdoo Gordon on behalf of Mr. McKinney. Hopefully that's. Procedurally, this case is here on de novo review as to whether the complaint states claims for breach of contract and due process violations. The factual basis, big picture, is that Darian McKinney, a government employee, a teacher, was blackballed by the DC public schools and then stonewalled when he tried to contest that misbehavior. The central focus of much of the legal analysis is a settlement agreement entered into by the parties in 2019. At that time, Mr. McKinney was a full employee of the department. He was in the process of grieving a prior adverse adjudication in 2018 before the Office of Labor Relations and Employee Management. Prior to that, he had contested 2 cases successfully before the DC Commission on Human Rights in 2015 and 2019, where the department had claimed that he had failed background checks. Mr. McKinney was given formal notifications of those allegedly failed background checks. He was given formal paperwork with appellate rights. He pursued those rights to the DC Commission on Human Rights and prevailed in both of those cases. In the summer of 2019, Mr. McKinney and the department were in ongoing litigation in front of the Office of Labor Relations and Employee Management on this non-background check issue, and they entered into a settlement agreement. The settlement agreement is dated November 2019, but it was made retroactive to August of 2019. On that date, I believe it's August 26th, Mr. McKinney ceased to be an employee of the department, and he had contractual rights from that point going forward. So what he gave up in the settlement agreement was his status as a full-time employee. He was fully covered, tenured. He had 4 years into his service. He needed only 1 more year in order to be eligible for a retirement annuity. And he was fully covered by the union contract.
Going back, you mentioned the emails that Mr. McKinney received from the DC Career Office. Did those emails attach or include a copy of a suitability determination
The original ones prior to 2019 did.
that he
There was
successfully appealed, but the ones from jobs thereafter?
Correct. After the settlement agreement, he received email communications from the Office of Security, not the Human Relations. There's a lot of sub-departments in this case.
Right.
So the Office of Security sent him emails allegedly saying that he had failed the background investigations. An interesting point on that is that he had never filled, after 2019, after the settlement agreement, he never filled out the paperwork to submit any background investigation.
The background investigation, what's the scope of it? Is it limited to criminal background, or does it include disciplinary or other conduct?
I would have to look at the regs, which I cite, to see if it goes beyond criminal background, criminal checks. It is primarily, of course, we're dealing with teachers, dealing with children, so it is primarily geared toward criminal conduct, but it's not limited to that, I don't believe.
So as I understand your argument is there's a provision in the settlement agreement that says he shall be allowed to apply for teaching positions at DCPS starting the 2020 to 2021 school year. And you want to interpret the covenant of good faith and fair dealing to require DCPS to, I guess, properly process any new job that he might get with DCPS.
Genuinely do the process.
Right, because it seems to me that he was allowed to apply and he otherwise would have been ineligible because he got a buyout. Because normally if you get a buyout, you're not eligible to apply for 3 years.
Correct.
So he did get something out of this provision, but you want to read into this something in addition, which is that they had to, in good faith, like process his application. Because they did consider his application. He got 2 job offers, right? But then where things fell apart was at the background check.
At the
That's at the
ministerial,
back end.
at the ministerial stage after the offer and acceptance, correct, for 2 of the counts.
And so I guess my question is, that's reading a lot into the words shall be allowed to apply. And why shouldn't he have had to negotiate better language here if he wanted it to extend all the way through the process? Because, correct me if I'm wrong, my understanding is if anybody just applies for a job with DCPS, there are no obligations to properly process background checks or anything like that. So he's asking for something in addition. Why does that need to be spelled out?
Unfortunately, that it is the state of the law that if a mere applicant comes to the district as a government entity and applies for a position, that the district does not have to afford them any due process. Some people would argue that that is not appropriate because the city is a government entity. But the state of the law is, as you stated it.
Well, you don't have an interest to be protected at that point.
Correct.
But basically, being allowed to apply doesn't confer any obligations on the part of the district to do anything with your application.
If you were a mere applicant, correct, I concede that point. But Mr.
isn't that what's
McKinney
in the
was not.
Settlement agreement, allowed to apply. He's asking for status to be an applicant. He wouldn't normally be allowed to be because he took a buyout. He wouldn't be eligible for 3 years. So he got something out of this provision. And then all he negotiated for was shall be allowed to apply. Why didn't he negotiate for something more if he wanted something more?
Well, he had union representation with him. And I think it's very unlikely that the union on the one side and the city's lawyers on the other thought that his ability to reapply meant that he could simply put in some paperwork and that was going to be it.
But if that's the default, why not? That's the default. Being allowed to apply means you put in your application, and the context is the district doesn't have to do anything with that if they don't.
Indeed, it is perfectly plausible because in some situations like that, the opposite might be true. Parties might agree you will not be allowed to apply anymore. We're signing off, that's our deal. Whereas this deal is you can apply. We're not going to block that. But
Right.
when you apply, you're in no different situation than anyone else who applies unless there's something in the contract that says that.
But he is in a different situation.
No,
because,
in the contract.
because
I'm looking at your contract argument.
Because unlike a mere applicant, he came into the settlement agreement as a fully vested employee. He, in consideration, gave up that status in
Right.
exchange for the right to reapply.
Right?
And as a part of a contract, he
In
has the right.
exchange for the right to apply, as opposed to, we're not giving you the right to apply. That's really what was going on then. They were disagreeing. And there was a negotiation. How are we going to end it? We'll give you a payment. You can apply if you want to, but as opposed to, we're not going to even let you apply in the future. You have the right to apply. And any person in a right to apply, so I just want to make sure you're understanding what's bothering me. In a right to apply situation, certainly is not guaranteed a position. They have an opportunity to apply, to be considered.
That interpretation would render the covenant to act in good faith completely illusory.
I think the
He would have
covenant
gotten nothing
has to be
back.
taken in context.
I thought your position was not that every time he submits an application, he gets better or different treatment, but that when he's offered a job and accepts the offer, then just like anyone else in that situation, he's entitled to a full and fair background investigation.
Right, he was entitled to the normal process. He
Right.
got less than the normal process
Right.
is what he
And
got.
the way he got less than the normal process, because he happened to have failed a background check in the past, he knew that he would get at least as alleged, a determination of an eligibility or whatever, the document from the security office,
Right.
and an opportunity to appeal that to is it internal administrative and then to the Human Rights Commission, or just directly to the Human Rights Commission?
I think it's directly to the commission.
Okay.
Right. So he was confident of what the process was going to
Right,
be,
so the
but he
reason-
didn't get it.
The reason I asked about whether it only covers criminal or whether it also covers other misconduct is one way to read the record in this case is that the settlement itself, the letter, the notice of settlement, refers to substantiated sexual harassment allegations.
Right.
And if there are substantiated sexual harassment allegations going forward from 2019, and if a background investigation takes note of those, then maybe anybody who has a substantiated, even if non-criminal background fact is going to be treated the way Mr. McKinney was. We don't have information about that.
But paragraph 3 of the agreement says that the city agreed to remove any investigation and notice of the substantial.
From his official personnel file.
Right.
But
So
as every employment lawyer knows, an official personnel file is only one source of information. If people conduct background check, if they call prior employers, if, that there are other ways to get information. So presumably they didn't get it from his official personnel folder. I don't know. I don't know enough about the process for conducting a background investigation, but that seemed to me to be one explanation.
What process do you think is due as a matter of remedy here that was not given by the district court?
You mean process going forward on an ongoing
No, I mean, it's
basis?
a due process case. You're claiming, I mean, at bottom, your claim has to be he was denied some proper process and we want it. I don't know what else your claim can be. He's certainly not guaranteed a job.
Correct. We
right?
conceded that
You can't be
point.
asking for that.
Right. That's what I wanted to know. If you wanted to know what ongoing forward-looking relief, what would,
I want to know what you think the relief is on a due process claim if, for example, some of us don't buy your contract argument that he's in this unique contractual position. Let's assume there is a,
I think it's damages for violation of his due process rights, his liberty interest and his property interest. Right? I don't expect the judge or the jury to award him the right to again reapply to the District of Columbia. What we're seeking is monetary damages because the failure to respect his due process rights deprived him of the final year that he needed for his retirement annuity. It deprived him of the employment income going forward. That income in the district is higher than what he's being paid in Prince George's County.
But doesn't that assume he would have gotten the job? Like if his damages are all of the retirement benefits he would have gotten if he had worked another year, you're assuming, and I thought you conceded he wasn't entitled to get the job.
Right. He didn't have a contractual right to be hired. He had a contractual,
And he also didn't have a due
Right.
process right to be hired.
correct. He had a due process and
So
a
I don't
contractual
understand how the
right.
damage can rely on him being hired.
yeah.
So as I take it, I just try to, what I glean from your briefing and the complaint is that Mr. McKinney is not claiming a right to a job. He's claiming a right to a fair process, including the right to apply, and including if he is deemed ineligible based on a background check, a right to know the content of the background check, and which he's had in the past and successfully appealed from,
Correct.
so that he could actually get some of the jobs he's held in the past, and that going forward, he thinks if they're still relying on that same misinformation,
Correct.
I need to go through the extra hoop. But I'm not even now, after the settlement, I'm not even getting that same standard process from the DC, whatever it is, Office of Security
Right.
that I used to get, so I can clear this up.
Right.
That's your position. So it's
Wait.
not
Right.
asking for
But-
anything
but
special. it's
stonewalled
asking
him
for
after.
ordinary process.
But
They
is that a right?
stonewalled the due process,
Wait.
their own
But is that a
process.
right?
Make sure I understand when you say like I used to get, when did he used to get this?
In the two previous times when he was told that he failed the background check,
Right.
he,
But not based on any city rule that required it and not based on the settlement agreement that he had with the city.
at that time,
They
it
just
was,
did,
no, at that time, it was based not on the contract because it didn't exist yet, but
right?
it was based on the ordinary regulations that give employees a right to appeal such a determination to the DC Human Rights Commission.
All employees who applied for teaching position in DC and were denied were guaranteed a right to a background check? That can't be right.
The statute
no.
requires the city to perform the background check. The statute requires the city to perform the background check
Any employee who applies.
for teaching positions, yes.
If they hire that person.
Right, if they make an offer.
They make an offer, yeah,
Right.
not as a general
Right.
matter.
Correct.
This is a little confusing. You're,
Okay.
when you say apply, you're assuming in your mind the acceptance.
Right.
But
Right.
here, I mean, isn't there a regulation? I thought that the regulation says that if an applicant is denied, the mayor or the mayor's designee shall inform the applicant in writing, and the applicant may appeal the denial to the Commission on Human Rights.
Correct.
So
And
if there is, I'm sorry, it seems to me that where we're all getting confused here
Yeah,
is that somebody gets an offer from DC, they will conduct a background check in the normal course, and then they have a right to appeal that if they fail the background check. But nowhere in this scenario is there a regulation or a rule or anything that says you're entitled to a background check if you get an offer.
No, but the city is required to conduct the check.
If you become a teacher, you have to have had a background check.
Yeah, it's part of
But
their process.
But I think what's important here is that what he is asserting is that in the past, I got background checks and got to appeal them. This time, I didn't get background checks and didn't get to appeal it. But underlying that is a claim that I had a right to a background check. And there is no such right to a background check because the city, for any general applicant, could just decide, we're not going to do the background check, and that person doesn't get hired. And there's no claim of action. There's no right that's been violated.
But the
Because
reason
they
that
can
he,
hire or not hire you at their will.
Yeah, I really need for you to hear what my colleagues asked, because that is what's bothering me.
you as well.
I am not aware of any such requirement. When someone comes in and wants a job in this department or others, there must be a background check. That never rang true to me, and you're not citing me to anything, certainly not the contract here, and there's no regulation that says it. If you get an offer, yes, they routinely will do a background check.
But he had
But
two.
we're not,
He had
I'm not
two
talking-
offers.
that's past us. He got the background check there. You're
No, he
talking,
didn't. No, sir. No, he had two offers of employment after the settlement agreement. There's two background checks before the settlement agreement.
Right.
And then there's two offers after the settlement agreement where the city claimed they did background checks and claimed that he failed them. And then for those two post-settlement background checks, he didn't
so
get any
your limited
process.
claim is there are two situations in which we think the law required a background check and he didn't get it. That's it, just two. There are no others that I can see.
I have three counts, but one relates to both relate to post-settlement agreement offers and acceptances, and then allegedly a failure of a background check. That's counts 1 and 3. Count 2 is in the interim between those two offers and acceptances, he applied for jobs, and even before he was told he got an offer, the city sent him something saying you failed the background check. So he didn't even get to that step.
Okay, so he got the background check. Now, what's your claim? I'm just trying to make sure I understand it.
Yeah.
He was told he had a background check.
He was told he had a background
Okay,
check
you don't-
and
you
then
don't
he
believe
failed
it.
it.
Now,
Right.
what's your remedy? What are you saying was the city's failure in that situation?
I'm saying they are falsely telling him he failed the background
What's
check.
your remedy?
Money damages. He wants money damages
Because he
Because
was
his-
falsely told that,
because
he had a
his right
background
to
check?
due process was violated. His liberty right to due process, his property right to due process.
wouldn't the remedy be background check?
If he were still wanting to get a job with the city, I suppose it would be to put him back to where he was and reapply again, possibly, but that's not what we're suing for.
And-
We're
and
suing
the
for money
evidence-
because his rights were
And your,
violated.
your evidence to support your belief that he really didn't have a background check? You're assuming something standard about a background check.
Well,
Let me just so you
Go ahead.
understand what's going through my head. You've had a couple of background checks in the past. You're not unknown to an employer. There's clearly a record. And it's not going to be unknown to those who are in the business of hiring people. Could a background check be, your name comes up and they say, oh, there's a file there? No, we looked at it. There's nothing different in what he's given us. Now, that's our background check. We don't have to do anything more. We're done.
Previously, though, whenever he'd had the background check, he had to submit paperwork each time.
That's precisely my point. There is nothing in the regulation that says a background check must be done in this way. Can a background check occur if someone already has had background checks and they've been negative and he is a known quantity in this employing situation? He comes in again, this known quantity is known. They look at his file and they say, no, we don't want to go with that person. Is that a background check? Why not if it's not in your
I
view?
thought your
Maybe, but it's a
position was-
deviation from their
I
procedure.
thought your position was that he had not had ultimately a prior negative background check because when he appealed,
He won every
he
time.
won every
Right.
time.
Every time he went to an
So if-
independent agency, he wins his
So
case.
if DCPS is relying, we know already we've been here before, it's relying in error,
Correct. They can't be relying on the
in-
priors.
conflict with
The decision
is
by the DC
either-
Human Rights Commission.
either his right to good faith and fair dealing, standard practice that everyone else would get,
Right.
and or his due process rights. Is that
Correct.
your position?
Yes.
But now there are substantiated sexual harassment charges. They're not in the file, but people know about them. So that's the difference between this background check and the ones he had before. Now there are substantiated sexual harassment allegations.
Right. That's what the settlement agreement says. And so in that situation, then even if you could say, well, that's all we need in order to say that he failed
Right.
the follow-on background investigations, but he never received from the city, they're claiming that he failed, but then he's never received from the city the actual notice and the actual appellate rights. So they're deviating from their prior procedure for
No,
how
no,
the
no, no.
background check is conducted.
No, in my head. What I want to ask you is, well, what reg says they have to do that, or what agreement says they have to do it? If they looked and saw the reasons for the prior experiences they've had, what more do they have to say?
Well, I cited the reg, Judge Ballard mentioned it, where if he did in fact fail the background check, he was entitled to appeal it to the DC Human Rights Commission.
Did he try and appeal in the later times?
Yes, this is what I'm talking about. So in the prior times,
No, get me up to date. The later times which we've been focusing.
in the later times, he was notified by email, not the official notification that he received in the past. He was notified by email that he failed. He then repeatedly contacted the department to say, well, I got this notice over here from security. You guys are then supposed to send me the official notice, which has all of my appellate rights, and the official written determination, because in order to invoke the DC Human Rights Commission's process, he has to submit that to the commission so they know what the case is about. It's like when the lower clerk here forwards the record to this court. So he needed the city to do all of that, but they just stonewalled him. They just refused to answer any of his emails or even communicate with
Part
him
of
at
your
all.
case on the due process violation, so I make sure I understand, is each time he was told that there was a background check, he had guaranteed right under city regs to say, I want to appeal that, and he should have been given the process.
Right. And that process did happen before the settlement agreement, and it did not happen after the settlement agreement, because these folks decided they weren't going to hire him no matter what. And we alleged that in our complaint, in paragraph 76. There was a witness who had told Mr. McKinney that higher up personnel in the department said they were not going to process him for employment, no matter what he did, in total violation of his contractual rights and his civil rights.
So at bottom, at least your contract claim hinges on shall be allowed means we will process you and give you a background
The
check.
normal way. Right. Exactly.
Even though normal people who are allowed to apply don't have that right. That's your contract claim depends upon him having rights beyond what other people who are allowed to apply have.
Yes, a small fraction, because a mere applicant, you don't have any of those rights. But Mr. McKinney is not a mere applicant.
No, I understand that, but it's
Yeah.
just not written to the contract. That he
Unless-
should have rights above and beyond what other applicants have. And on your due process right, then your claims depend upon, he has to have a due process right in getting a background check and appealing the background check. That's what he was entitled to.
I don't know if I would articulate it that way, that he had a due process right in the background check. The background check is a mandate of the city's obligations for the hiring of teachers. He doesn't have to have a right to that. That's a normal
No, but
part
I'm
of the
just trying to say
process.
but what you're saying he was deprived of was the background check.
The normal part of the process, yes. Right. In this instance, it is the background.
And I mean, you're saying he didn't get the background check, but more than that, like the regulations talk about the ability to seek review. And they say that the petitioner, in this case, Mr. McKinney, shall file a notice of appeal along with a copy of the suitability determination being appealed. And as I read your complaint in your briefing, a central part of Mr. McKinney's argument is that he's entitled to a suitability determination and he never got one.
The last two times. The first two
last two
times he
times.
did,
The
the
last
last
two
two times he didn't.
Right.
Right.
And I mean, setting aside the applications where he got the sort of what I
Brushed
think
off.
You characterize this like a premature unsuitability determination.
Right.
If you have a suitability determination and it's in the situation of a school, in other words, a safety sensitive position, child or youth services, the determination is essentially establishing that the person presents a danger.
That's what the
to
reg
children.
says.
That's what the reg
Yes.
says.
Yes,
So that's the liberty interest, is that somebody
Correct.
who has been deemed
officially,
this
to be a danger to
determination.
children, yes.
to be a danger to children or youth.
Right.
And has no determination so saying, and has no ability to appeal it
Right.
to the DC Commission on Human Rights. And I guess my question is, this isn't briefed, and I'm puzzled by why it wasn't briefed. But assuming that the background check looks into more than just criminal background, there's a settlement that says there's substantiated sexual harassment against this individual. Why do you, if that's part of a settlement,
Right.
I'm not sure there's a need for an appeal, but I mean, this will be a question for the government. But if there's substantiated sexual harassment allegations, typically an appeal is needed to say, no, that's not the case. But in a settlement to which Mr. McKinney agreed, it says it is the case. I'm looking at paragraph
Right.
2 on page JA
I
24.
mean, that's
Right,
the
I'm
part
looking
you're-
at it as
you're
well.
glossing over. There was a settlement here. Certain things were assumed, and I don't see anything in that settlement saying you're entitled to the kind of process you're now claiming, and I certainly don't see it in the regs. Normal person coming in the door doesn't come in with this kind of paperwork.
And I guess what I understand your position in light of the settlement is that he's entitled, in light of whatever that was, to a suitability determination, to something that actually looks at that and says, well,
How much
What
weight
is
to
it?
give it? Because
How much
this
weight to give
settlement
it?
was before the Labor and Relations Board. He was entitled to another determination by the Human Rights Commission. If
Right.
the city was going to rely on the settlement and say, well, we have these substantiated sexual harassment thing, he was entitled to at least argue that doesn't justify you denying my background investigation.
and just for clarity, the acts that are referenced in the substantiated sexual harassment, that's distinct from the acts that were the subject of his 2 prior
Correct,
disqualifications and appeals.
correct.
This is new material.
New material.
Okay.
Any other questions? At least we
you.
didn't have to parse through the FAM in my case.
Ms. Johnson.
Good morning. May it please the court. The allowed to apply language in the settlement agreement was not crafted out of whole cloth for the settlement agreement. That comes directly from the collective bargaining agreement. And unfortunately, there's no page numbers, so I'm going to give you the article numbers where you can look those up. At the collective bargaining agreement, 4.5.7, and again at 39.8. The first that I cited has to deal with teachers who are excessed, and the second has to deal with teachers who are rift, but both involve separations due to an excess or a rift, and they have the same language. And they say, separated teachers shall have the right to reapply at any time. If rehired, they'll start at the next salary step, and if rehired within 1 year, there's no break in service for pension purposes. I want to be clear, that's the only purpose for which there's no break in service. So
But for probationary purposes, there is a break in service.
that's absolutely correct. And that's why I wanted to emphasize that, even though that's not part of the contractual, that's more the property interest side, but I want to make sure that's emphasized while we're talking about this. So the collective bargaining agreement, the settlement agreement, once it's read in context with the collective bargaining agreement, the only thing it promises is that despite taking the buyout, Mr. McKinney is going to be allowed to apply the next year instead of having to wait for 3 years. And that promise wasn't anything special. That is the same right that anybody gets under the collective bargaining agreement if they're separated. It just allowed him to take the buyout, even though the time for doing so had passed. He then released all of his challenges against the administrative actions being taken, the employment actions being taken against him, and they settled for that. Nowhere in there is there some right to a predetermination background check.
No. But what about the jobs? You get right to apply, presumably in something. It's not an empty phrase. So he applies, gets offered the job. Typically in, the private sector, done deal. But schools, so the government has an obligation and does a background check. And his claim is, but you're not doing the background check the way you do it for everybody else. You're giving me a ding before I even get a suitability determination. You're treating me as unsuitable up front. I mean, that's alleged. I don't know whether that's what happened, but that's alleged. And that seems like that does state, or why doesn't that state a violation of good faith and fair dealing? And why doesn't that impinge a liberty interest in a reputation when it's saying you're a danger to children?
So there's a lot to unpack there, and I want to
I
take
know.
it in a few different
Tell
pieces.
us.
I will, I assure you. So let's start with just the factual allegation that he was offered jobs. He says he was offered jobs by principals. Now, a principal might say, I like you, and I'm going to recommend that you get offered the job. But by law, the chancellor is the one with the final discretion to say yes or no. So he didn't have binding job offers
But you're
from
not telling me
DCPS.
that every person hired in DCPS actually goes and gets checked off by the chancellor. That's sort of a legal background. If there's a problem, I presume that is a way of effectuating the background check requirement.
Well,
If his background check came through flying colors, he still would have had to get a chancellor sign off?
I think that the chancellor would have had the discretion to say no, absolutely.
No, right.
Absolutely. But I think that matters for purposes of the contract.
It may matter for purposes of due process. I'm not sure it matters for purposes of the contract.
So then let's move forward on that on the contract, and let's
Yes.
assume that. Well, he's still, nothing under the contract gives him any right to sorry, I'm reframing this in my head because to me, he didn't have a job offer. Like, I don't see how he could possibly claim to have a job offer when his job was being submitted to headquarters to see whether they would hire
Okay.
him.
How
But-
do you put that? He had a principal that wanted to hire him,
Mhm.
subject to approval downtown.
So I think that any teacher who has been previously employed and they're reapplying and it's subject to approval downtown gets a chance to consider whether that's the person they want to hire.
Right.
And nothing
He's
is,
saying part of that background check, part of that is a background check. A background check looks at your background and makes a determination about it, tells you what it was, and if it's wrong, you get to appeal it. You don't deny any of that, do you?
but you don't get any, I don't deny that, but you don't get that until you've been given an official job offer, a formal job offer from DCPS,
Wait.
not from the
They didn't
principal.
deny they did background checks. They claim they did them. In fact, it's the plaintiff that's saying you didn't really do it. So the position of DCPS has to be, we proceeded into the background check stage, not that the chancellor didn't even allow that to happen.
Right now, the position of DCPS is that we're looking at the four corners of the complaint, and the four corners of the complaint, to be fair, say, we don't think a background check was conducted. It's not saying for sure there wasn't, so you have to look at it both ways. But we're not at a place in litigation yet for DCPS to be saying what happened. There's been no discovery. What we're saying is, if you look at the four corners of this contract, it would be astonishing and implausible that DCPS would have agreed that a jury gets to decide whether this individual was given fair consideration, and that a jury would get to decide whether any person who was separated and reapplies.
You go back, if you went back to the district court, there would be summary judgment proceedings. You would say, you don't deny this document, this document, this document. The chancellor sent you a letter saying, sorry, we're actually not interested, so we're not going to do a background check. Like, okay, or we did one and here's the notice of determination we sent you, or whatever. I mean, but so you wouldn't go to a jury necessarily, but we're looking at allegations. And the question is, do these allegations state a claim that even though this person had a protected right to apply, he was not treated in the regular course of application that would apply to anyone else? He was dinged in a way that's contrary to the regulations, and that's contrary to the usual process. That's his claim.
I mean, I see that that's his claim. And we think that the contract is so clear that there'd be no need to go beyond the four corners and go into what the parties intended or what happened. But
Can I ask a question?
Wait, let me just get an answer to this. What is it clear about?
it's clear that the only thing that was promised was that he would not be precluded from applying because he took the buyout. He was not precluded from applying because he took the buyout. That's the only thing that I think that the contract can be read to provide. It's very careful language, right to apply. And I want to point out and I do want to have time to get to the constitutional claim, so I understand where the court comes from this. But I want to point out that the only hiring case, I mean, hiring decisions are very discretionary. There's a lot of judgment involved. And the only hiring case that Mr. McKinney has come up with is from a district court in Oregon where somebody had a right to apply for a vacancy. And the only reason there was any sort of hint of an implied covenant of good faith and fair dealing is because in that case, the school district privatized its janitorial service and got rid of the vacancies altogether. I think the implied covenant of good faith and fair dealing doesn't mean that your application is going to be given some sort of fair consideration or extra consideration. I don't know what that means. That's beyond the rights that someone else would have. And I don't think that this court, because of that, has any reason to get into whether or not there was a background check or anything like that. So that's where we think that the contract stands. I understand if this court thinks it needs factual development. We just think that that would be futile given the language of the complaint and how it connects to the collective bargaining agreement.
So it seems to me that a lot of this colloquy stems or relies on the fact that he's being treated differently from other people, and somehow that implicates good faith and fair dealing. I thought it was useful that you said that this term allows to apply comes from a CBI. Is that understood in the context of the CBI when you're allowed to apply, that means they're going to in good faith process applications and that kind of thing?
All I think it means is that you're not precluded from applying because of something else in the collective bargaining agreement.
Your answer is no. CBI allowed to apply doesn't mean you're entitled to a background check or any processing.
I think that's right.
And then average applicants, anybody who walks in off the street and applies for a job with DCPS, do they have a right to a background check if they're offered a job?
No, they don't have a right. They don't have a right to an offer. They don't have a right to any sort of process until they are formally hired, until they have signed the hiring documents.
So it could happen, just a hypothetical, somebody gets offered a job to be a gym teacher at Elliott Middle School. And at that point, DCPS decides just not to do the background check. Do they have a right to that background check?
No, they don't have a right to that background check. And I just wanted to be clear.
So therefore, what is being asked for in interpreting just allowed to apply in this settlement is that somehow this Mr. McKinney was entitled to something above and beyond what other employees subject to the CBI get and what other applicants off the street get, but it's not written into the contract.
That's correct. That's correct. And I want to explain my hesitation when we start talking about good faith. Obviously, we want our government officials to act in good faith, and obviously it's best practices to do so. But when we're talking about the implied covenant of good faith and fair dealing, I'm talking about a specific covenant under the contract, and not every term of a contract is going to be susceptible to violations of that without some sort of absurd hypothetical. So anyway, with that in mind, I would like to turn to the constitutional claims that have much more far-reaching
I
consequences.
just have one question about that. When Judge Pan asked you if under the collective bargaining agreement, you're allowed to apply, let's say after 3 years, or what's the standard term that this is modeled on? You said this is modeled on a standard term of a collective bargaining agreement?
Yes, it's the collective bargaining agreement for the teachers union and the
Where if
district.
you're laid off, you get to reapply after 3 years?
No. If you are laid off,
Yeah.
if you are separated and pursuant to that, you may reapply at any time
Right,
unless you took the buyout.
right.
And
And
then,
this is giving him you may reapply at any time, even though he took a buyout.
correct.
So it's sort of melding two different statuses. But you're saying that under the collective bargaining agreement, a right to reapply doesn't mean a right to be treated as any other applicant?
No, I apologize.
I heard you say no in answer to her.
I think I was confused by the phrasing of the question, or maybe it's just my own problem. I apologize for that. It gives you the right to be treated exactly as any other applicant and other.
It's exactly the same, which is you don't have anything until someone hands you a piece of paper and says you're hired.
That's exactly right.
You have a right to go through the process as the school defines it, and you wait and you hope for the best.
And you don't have, and this is what I think sort of segues into the property interest, because I think this is important. You don't have a property interest to not be hired without cause before you're hired. And then you have to serve, and then you have to serve.
We're talking about good faith and fair dealing is a different threshold.
It is. I'm sorry. I was turning to that before, if that was before the court was ready.
Good faith and fair
Yes.
dealing, it gives you the right to be treated as anyone else. And DCPS, it's not that you have a right to a background check, it's that anybody who's going to be hired, that a principal wants to hire, has to clear a background check, right? It's not that you sort of can say, oh, we're not even going to do that.
No, anyone the chancellor wants to hire and is formally offered a job by DCPS itself, then gets a background check, and they don't have a right to the background check. It's just that if they formally fail the background check, they can appeal that.
Right. But if the principal wants you, and if it's fine with the chancellor to hire whoever the principal wants, then you still would have to have a background check.
Yes.
And there is an ordinary way that that happens. And if you fail it, you get a notice of determination, notice of ineligibility, right?
I mean, I think
pleaded.
it's alleged in the complaint to be standard practice. That's
Right.
not in the law, that you get a
it is
formal
in the
determination.
regulations, which say that in order to appeal, you need to you bring your final suitability determination to the Human Rights Commission.
Well, and I apologize because I was jumping ahead from contract to liberty interest because, the regulations do say you're supposed to get a formal determination. But I don't think that the denial of a formal determination means that somebody has not been given the process that they're due. Mr. McKinney knew he could go to the Commission on Mental Health, on Human Rights. And there's no way that if he had gone, I know I'm jumping ahead, I apologize. But if he had gone to the Commission on Human Rights and said, I have an email saying I failed a background check, but the agency won't tell me why, the Commission wouldn't deny his appeal. The Commission would have said, well, DCPS, why did he fail? And then DCPS would have said, oh, he didn't, or he did, and here's why. And they would have proceeded. And I want to point this court to McCormick on this point, because in McCormick, the plaintiff did not think he had a right to appeal. And the court said there's a provision in the CMPA that gives you a right to go to the Superior Court if you think that you were entitled to severance pay, and that would have given you the name clearing hearing. And again, I'm going out of order here, but I want to give this court one other site that's not in my brief because I think it's important to this point. It's Johnson, Sally Johnson versus District of Columbia. The citation is 552 Federal 3rd 806. And at footnote 8, this is an employee who was claiming that the district refused to proceed with arbitration when it was supposed to. And what the court said was that she had all the process that she was due because the law gave her an administrative remedy to go to PERB and force DC to arbitrate. So that goes much further into liberty interest than I think is necessary. I think there's other ways to deal with the liberty interest claim, but I find it astonishing that Mr. McCormick doesn't think he had a right to appeal when the law gave him a right to appeal and he did not attempt to do so.
In fact, he could probably now bring a Section 1983 liberty claim in Superior Court or in the district court if he wanted to.
Well, this is a Section 1983 liberty interest claim. I mean, that's the claim he's bringing. It's just, we don't think that he states a claim. And I'm happy to turn to liberty interest. I think that that's important to do so. I have a couple layers. So with the court's indulgence, the first thing I really want to point out is he's forfeited his debarment claim. He did not make a debarment claim in the Superior Court. If you look at Record Document 8, that's his opposition to the motion to dismiss, at pages 8 to 11, all he talks about is an injury to his reputation if DCPS published their determination that he failed a background check. That's all he says. He never says that he was formally debarred. And even his last paragraph, there's a fragment of a sentence that says that he was completely precluded from obtaining any teaching position in any public school in the district. And the sentence goes on to say, and would be as well from any other school in the district. As a result, he's foreclosed from entering the field. So I just want to lay that out there that we think that's forfeited. But even beyond that, if you look at the liberty interest, there's sort of two different sides of looking at it. Either there was a formal determination or there wasn't. And if there was a formal determination that he failed a background check, even if that could be relied on by, even if that was binding, which we don't think it was because it's discretionary for future job offers, 1 year debarment from one agency cannot rise to the level of liberty interest deprivation. And we know that from this court's Langman decision 2 years ago, where this court said that even if someone was automatically formally precluded, a special agent, from ever working for the FBI again, that doesn't rise to the level of a liberty interest deprivation. And so given the high bar that you have to clear to show that you've been denied of not a property interest, but a liberty interest in following your chosen occupation, there's just no way to square Langman where somebody couldn't work as in his field for the FBI ever again, and somebody where the District of Columbia, DCPS just didn't want him, didn't want to hire him. So that's if it was formal. If it was informal, I mean, Mr. McKinney is trying to argue that you can be informally debarred, but not have to satisfy the broad preclusion standards that are required for that standard of the stigma plus test. And it's one or the other. Either it was formal, automatic, binding exclusion. I believe Crooks uses the word change in legal status. Either it was that and it was formal, or if it was de facto debarment, he has to show that this would preclude him from obtaining other work in his chosen field. He clearly can't do so. He's abandoned that claim and is now only pursuing the debarment claim. So I want to make sure, I know my time has run out, and there's a few things that I just want to make sure I cover that came from the reply brief. Mr. McKinney, in support of his claim that he can pursue a debarment claim as opposed to the broad foreclosure claim, says that in Campbell, this court said that that was a jury question. But Campbell was not a formal debarment claim. It was a broad foreclosure claim, and that would be a much, I mean, we don't think it's a close question here, and he's abandoned that claim here, but that could go to a
But
jury.
under Kartseva, there's the binding disqualification, and he relies on Kartseva, and he says that this is a legal conclusion by DCPS that he presents a present danger. And so even though he can work in Maryland, he's debarred in DC. I'm not sure I'm seeing I know you're making a forfeiture argument, but when I look at the district court document that you're citing to, it doesn't seem to me that clear that it's limiting itself to the broad preclusion as opposed to the formal, but perhaps more limited debarment claim. It seems like they're both in there.
I mean, this court can consider the claim even if he did forfeit. So what I'm pointing out is that the point of issue preservation is to put people on notice of the argument that you're making, and nobody thought he was making that argument until appeal. The district court didn't think so. The District of Columbia didn't think so. So that's all I'm saying. But if we're dealing with the formal binding debarment, there's so many layers by which he doesn't state a claim. First of all, he says that there was no formal determination, but even if there was a formal determination, it wasn't binding because at 6B DCMR 406.9, this is cited in my brief, it says that an adverse suitability determination may be relied on in future job applications at the discretion of the personnel authority. And I would contest that discretion means that it's not automatic or binding. So there's that layer in which we think that claim fails. But even if this court says, well, we think that that's binding enough, then we come down to the fact that it can only be relied on for 1 year and only for DCPS, not for other schools. There are more than 200 non-DCPS schools. I apologize, I'm winding up. There are more than 200, I mean, I just looked it up on Google, so there are more than 200 non-DCPS public schools in the district alone. If in Langman, a special agent with high skills in investigation, if his permanent debarment from working for the FBI ever again can't rise to the level of a liberty interest, then what is at most a 1-year debarment from working for DCPS cannot either. And then of course there's our background, our final argument, which is that he had the process he was due, even if this had turned into that sort of a deprivation.
Thank you.
Thank you.
So, some interesting points here. My friend adverts to where we are in the litigation, not at this place in the litigation. So there's been no discovery, I would note. We're very, very early in this case. It's motion to dismiss. And I think that contrary to what's asserted here, what the discovery will show is further proof of what we've alleged. The really bad acts in this case are behind the scenes. All of those facts would have to come out in discovery because they're purely within the purview of the defendant in this case. I also understood the argument from the city to be that somehow the covenant of good faith and fair dealing doesn't apply to the collective bargaining agreement. And I think the Washington Teachers Union would be shocked to know that the city is taking that position. I think that's clearly not correct.
I think she disavowed that.
Perhaps later. In terms of what arguments were raised below, were not raised below, I would remind the court that we're on de novo review in this case of a 12B6 motion, and that consequently, this court's obligation is to examine the complaint independently to determine if the factual allegations could provide for relief under any viable legal theory, even one not mentioned therein. This is Edmonds v. U.S. Postal Service, a concurrence and dissent by Judge Silberman. What the court has to do here is determine whether the complaint states causes of action. You're redoing what the district court did. You're not deferring to that judgment.
And on the liberty claim, you're not asserting a reputation plus or stigma theory, right? That's what it says on page 23 of your.
We're right. That's kind of gotten refined as we've gone. What we're asserting is most clearly stated in my reply brief, which is under Cartseva. It's sort of a subpart of the
debarment.
Stigma plus. Yeah. So,
So she said you're not asserting a stigma plus
right.
theory, and you just said, yes, we are a subpart of the stigma plus theory.
In the reply. That's the last argument in the reply.
Stigma theory based on preclusion, stigma debarment, right?
It's just a debarment theory.
Correct.
Which is
I
a form of
misspoke.
stigma plus theory.
It is. It's one of the subparts. Cartaseva makes it clear that there's sort of two versions of that. We're under one. And it obviously is clear that Mr. McKinney is teaching in Maryland, but the fact that the district has effectively debarred him from any teaching position in the city is really the issue. So as I said in my papers below, that he doesn't have to be debarred by the city from any teaching job in the entire universe of the planet. The problem is that he's debarred from teaching in both public and private schools, because even the private schools in the district have to go through this background check because their positions are for teachers. There is also, and I cite this in the reply.
So, but your complaint says he didn't get background checks for the two that he.
Right, but
got
they're
offers
claiming.
for. I know, but
Yeah.
I'm just want to understand, have you alleged in your complaint that he's forever barred? And he'll never ever get a background check if he ever gets another employment opportunity? Because that seems to be required by this debarment theory, right?
Well, if the city is going to maintain the position that it has, that he is
But you have to,
debarred,
I guess,
and the
allege
answer
that-
is yes.
So
Right.
your complaint has to allege that he will never ever, if he ever gets another offer, get a background check again, doesn't it? Because that's a different theory from I was entitled and you already deprived me of the ones I got.
I think
This is the
we
new
would.
theory.
I think only we would have to allege that he was precluded from any position in the district.
In what
Uh,
time frame, though? I mean, just not getting two jobs doesn't mean that you're excluded from it.
Well, I think the
range of
pattern is
employment.
clear that it doesn't matter how many times he applies. He's never going to be approved
Right, but you
for
have to
the
allege
job.
that. To support this theory, you would have to allege more than he didn't get background checks for two. You would have to say, and that precludes him from ever getting any job.
And so that I understand, what do you think is the stigma?
That he's been.
The mere failure to get a position?
No,
Or some accusation about past activity? What is the stigma,
the fact that the claim by the city that he failed the background check
right?
legally means, pursuant to city's regs, that he is a danger to children. That the regulations say if you fail the background check, that's what the determination concludes.
And you're referring to the final suitability determination shall establish whether the appointee or employee presents a present danger to children or youth.
Correct. He's a teacher and a coach, and he's been determined by the city to be a danger to children. This is
As if
absolutely,
an applicant is denied because he presents. Can't you, that's what I'm looking at. 1501 it says, if an applicant is denied because the applicant presents a danger to children. Can't you be denied a background check for reasons other than that?
well, nobody knows what the city's reasons are in this
Or
case.
do we even
because-
know what he's been denied why he's.
Because the city won't say. That's the whole
Oh, but
point.
that's exactly my point. What's the stigma? So in other words, there are plenty of people who can be in a situation where denied a background check. We don't assume that it has to do with this particular regulation.
I think for teachers, yes, we do. We assume that it means that they're not safe to be
Why do we
around
assume
children.
that if you're denied a background check, the only reason?
Because the reason they're being subjected to the background check is because they're around children. That's the purpose.
No,
Yeah, this is.
that it says this reg says because the applicant presents a danger to children. But there are other reasons a school might not want you working around children, not necessarily because you're a danger, but because in their view, we just don't want you in our school. You're not the model we want. You all have been equating this dangerousness thing as if it's a given. It's not in the record that that's what they ever said. Indeed, that's somehow strange, would be strange, given that there was a settlement. He washed away. It's not making sense. He settled this case.
No, he settled the case from 2018.
That's right. Well, that's involves him and whatever it is that people think about him. And I'm not sure where the assumption about dangerousness comes up. It's not anywhere.
It's because the purpose of the background check is to
Where does it
ensure
say
the
that?
safety of children.
Where does it say the only reason the schools use a background check is if we're concerned? No, actually, the way you're saying it, if you're denied a background check, it will only be because a determination has been made that you present a danger to children. I don't know where that's coming from.
I don't have the regulation in front of me,
I
unfortunately.
do.
But
And that's not what it says.
not every job in the city is subjected to this background check. It has to do with safety considerations, the kinds of jobs that are
No,
run
we're talking
through.
about a stigma. You've got to show in in all this case law you've been pointing to, you're forgetting the stigma part. The mere fact that you're denied a background check is not necessarily stigmatizing when no one has said simultaneously to the world or anyone else that this person is a danger to children. And there's nothing that says the only people who get denied a background check are those who are dangerous to children. That's not what the reg says.
But for a teacher to be denied a
No,
background
that's not
check
what the reg says.
carries that implication.
So I'm really confused about this, and I actually meant to ask the government if the background check is more than a criminal background check, and maybe we can actually
Would you like to step
hear
up?
from, just do you have any legal sight? Sorry to call you up, I know that's not.
No, it's fine.
not regular.
I meant to address it. This is not something that was raised in briefing. I didn't bring the statute with me. I don't know the answer.
So there is a statute about criminal background checks. And that is DC statute 4-1501.05A. And it says the information obtained from the criminal background check shall not create a disqualification or presumption against employment or volunteer status of the applicant unless the mayor determines that the applicant poses a present danger to children or youth. And then the regulation says for appointees to and employees in safety-sensitive positions at a covered child or youth provider, the final suitability determination shall establish whether the appointee or employee presents a present danger to children or youth. So
You must
if
be
that's
looking
the
at
background
different
check we're
language.
talking about,
Aren't you looking at the information obtained from the criminal background check shall not create disqualification? No, the one up above, if an applicant is denied, but it doesn't tell an applicant.
because the applicant presents a present danger to children or youth, the mayor shall inform them in writing and they may appeal.
Because the applicant
Right.
presents.
Right, but that, the A, which that is a procedural concomitant to, says that it's not a disqualification.
Right.
Unless there's a present danger and in making that determination. So
And
to
all,
me, this does suggest that a denial is based on a determination that you're a danger to children or youth.
I think, if I can proffer, that some of the disconnect is between what's being called a denial of a background check and what's being called a failed background check. The district's position is that Mr. McKinney was not entitled to any of this because headquarters did not offer him a job. His name was submitted by a principal who didn't know him, who didn't know anything about him, who didn't necessarily know his background with DCPS. He gets submitted to headquarters. Headquarters decides they don't want to hire him. He's not entitled to anything else. I do not know what is involved in, I mean, first of all, I don't know what the email said that he purportedly got that said he failed a background
Would you
check.
answer this question? Is it your position that a denied background check means that a determination has been made that you're a danger to children?
No, no.
And
That's
you-
what
you don't
they're
have any
assuming, and I don't see it. That's what my colleague and I are going. I've never seen that. I don't know. That's why I don't know where the stigma is coming from.
Well, and there would
Merely
be,
because you've been denied a background check.
and I apologize because I know I'm up and we're in rebuttal and everything's gotten a little confusing here, but the stigma claim has been waived. She's not bringing a stigma claim, she's bringing a debarment claim because DCPS didn't tell anybody. The stigma comes from DCPS
No,
publicizing.
I want to go beyond that. You may be wrong on the waiver of forfeiture. I wanted to understand, because I've never really understood this, and I'm sorry I waited as long as I did. Is it agreed between the parties that if a background check has been denied, the assumption is a determination has been made that you're dangerous to children? I have not seen where that is supported. It is stated, but I haven't seen where it's supported.
Yeah, and I haven't seen that either. I don't know. I apologize that I can't give a better answer. This is not something that was raised in briefing. And
I think it was. I mean, well, and to me, it's this A, it's 4-1501.05A. The information obtained from a criminal background check shall not create a disqualification or presumption against employment or volunteer status of the applicant unless the mayor determines the applicant poses a present danger to children or youth. And the inference
Means you can
is,
still be denied for another reason. You can still be denied a background check for a different reason. But if you're going to get into the dangerous to children, then we get the mayor involved. That's the point I'm trying to make. That's a limited category. I don't see anything anywhere in these papers that says that a denial of a background check means a determination has been made, with or without the mayor, that you're a danger to children. I just don't see it, other than the brief assertion.
If I can speak to that, I think the language means.
Thank you.
I think the language means, as Your Honor, Judge Pillard is saying, is that doesn't make you ineligible unless there's a determination that you're a danger. Ergo, if you've been denied, if you've failed in their, inartful language that the email is using, that means ipso facto, you present a present danger. And I allege this in my complaint. It's paragraphs 90, 91, and 92, saying that being labeled in this way would subject anyone to embarrassment, humiliation, approbation, loss of reputation, stigma, and ridicule. That their actions unlawfully harmed his reputation, stigmatized him, subjected him to embarrassment. Also, as I argued in my reply, he's going to have to tell people when he applies for his recertification, he applies for other schools, that he was denied this background check on this basis. So he's going to have to self-report
That is a danger to children?
Yes,
They've never
according,
said that to him.
that's what the regulation says.
No, so can he be denied because the city thinks he maybe drinks too much?
The statute says.
Can he be denied for that reason after a background check? Is that a possibility?
Not under this particular reg,
Can
no.
he be denied after a background check that they think he drinks too much? Not even in the classroom, they just think he drinks too much. After a background check. And if asked and they were forced to tell, they say, yeah, we did a background check and we made that determination. We're not giving them the job.
I don't think that would be consistent with this regulation.
Would it be consistent with the law for them to do that?
I don't think so, no.
Really?
does that pose a present danger to children or?
Well, no, I wanted a hypothetical where he drinks only at home, he doesn't drink in the classroom. No, I mean, there's so
Maybe
many other
there
examples.
may be a different basis for them not to hire him on.
After a background check. But they say we did a background check and now we have any of a number of bases that are not dangerous to children.
But this is labeled specifically
Yeah,
in the code as a
hear you.
criminal background check.
I hear you.
Yeah.
I'll think about it, but
The last point that I would like to make is that in terms of he could bring a claim under 1983 in the Superior Court, I would note that, as counsel notes, that's what I'm doing. And I filed this case in the Superior Court and the city removed it.
I don't think you said it, section 1983, but you meant to.
Making the due process constitutional arguments.
Okay.
It's definitely what it is.
Thank you.
Thank you.
All right.
Case is submitted.
This honorable court has adjourned
The Wednesday already?
February 20th at 9:30.
Tuesday.